Thank you, Mr. Speaker. I rise in opposition with some comments.
Opposition, please proceed.
I just wanted to preface my comments by saying, long live agriculture. I'm a huge proponent of ag lands, water. I wanted to include the public trust doctrine, which prioritizes customary traditional practices and the health of native streams and coastal life over private commercial uses. As well, in 1987, the state of Hawaii adopted a water code which said the waters of the state are held for the benefit of the citizens of the state, and it declared that the people of the state are beneficiaries and have the right to have the waters protected for their use. In 2001, that's when the East Maui Terra farmers first filed a contested court case against commercial use of the water and wanted to divert this water back into 27 streams on East Maui. In 2005, Judge Hifo ruled in favor of the Terra farmers and required an EIS, which I believe, which I can't be corrected, but I believe the EIS or the EA was not completed till this day. In 2007, BLNR granted interim relief to the Terra farmers and allowed 6 million gallons of water to go to East Maui. In 2008, BLNR ruled an additional 12 million gallons go to help the Terra farmers, but that was never the case. So they filed a bunch of court cases from then until 2015, when Dr. Lawrence Mike, a hearing officer in the contested case, recommended that there is sufficient water to support sugar production in central Maui while allowing the streams to flow in East Maui as the law requires. So I think that's where the discussion stands, is there really enough water to help Central Maui as well as give water back to the streams on East Maui, which is what the original court case in 2001 was about sharing the water, sharing the resource, not diverting it so that only one section gets it, but actually letting the land breathe and get life again. In January 2016, Judge Nishimura ruled that the state law does not authorize BLNR to hold said revocable permits for more than a dozen plus years because that does not meet common sense definition of temporary. So I think really the question is if the EIS or the EA was actually done and determined how much water is needed for that area and how much water can be diverted back into the streams in East Maui. If that was ever done, then we could have a conversation, because I believe that actually the County of Maui already had this situation where they had to present to the circuit court saying how much water they needed and for what purpose, and they were allowed to do it. But that's what the question is here, is how much water is needed and for what purpose, and then allow the other waters to flow back to the areas that are needed for the private trust, which I read in the beginning, necessary for other types of agricultural production. So it's not to put one over the other, it's actually to support many agricultural productions that are happening. And so for those reasons, those are my concerns with only diverting it into one area as opposed to what the law has stated. And I'll say for the previous speakers, I commend them for saying that fairness is what we need here. And also keeping the law is what our governor stated in his State of the State address, is that recently we haven't been following those laws. So since 2001 till now, with all these court cases and all these rulings and all these determinations about BLNR, we need to just do an EIS or an EA and determine where we're at with this and let the waters flow like stated in the water code that's in our current statute in law right now. Thank you, Mr. Speaker.
Thank you very much. Any